thing that I'm going to talk about today is section 53(1)(c), which, like wills, is a substantive rule. So in this rule, if you're going to make any disposition of an equitable interest, this needs to be in writing. Now, the question is, well, what does that really mean? So remember, we've got our property and we separate it into legal and equitable interest. This equitable interest that the beneficiary holds, so the trustee's got it. But let's say I've got beneficial interest in something. There are various things that I might want to do with that. It is still property. It is still a right that I have. And it might be, under certain circumstances, I might be able to sell that right. I might be able to give it to someone else, depending on what it is and what property it is. I might make a contract about that right, saying, well, once I get a certain amount of money paid from the trustees, then I will pay it to someone else, or I will give the right to someone else, or I will direct for the trustees to hold the beneficial right for someone else. It used to be just assignment, or the statute itself just says assignment. Since then, it's been decided any disposition. So not just, you can assign a right by saying, I now want this right to be held for someone else. But there's other things you can do. They list them out in 6.3.1. So disclaiming the interest, surrendering the interest. So saying this, I'm no longer going to try and enforce this. A contract to say I'm going to assign this rather than just assigning itself. There's a whole list. Anything can be a disposition, any dealing that a beneficiary might have with their beneficial rights. It needs to be in writing. That's the important rule. And if it's not in writing, it hasn't been done. It's not that the court won't accept any other evidence, or the court but the court still, or the law would still recognise it to be valid if somebody else was dealing with it and it wasn't in dispute. That's not what's happening here. It's that it needs to be done in writing to be done at all. And the question that they sort of leave hanging with in this chapter is why? Why do we need this? And this could be the subject of an essay question. And you need to be looking at Gray and IRC and Vandervelde and IRC. And if you're wondering, well, who are IRC? It's normally, I think it's called Inland Revenue and Customs, who are the tax authority. We now call them HMRC, Her Majesty's Revenue and Customs. Actually, I don't know why that changed. Maybe there is still an Inland Revenue and Customs. Anyway, they're the people who collect tax for the government. And although they have made themselves famous in general trust jurisprudence in the UK, Mr. Gray and Mr. Vandervelde were basically just trying to avoid tax, trying to do something quite clever with their beneficial interests. And I think in both cases they said no. The tax authority certainly didn't let them get away with it. And the important thing is that the conclusion that the subject guide come to is that the reason that things need to be in writing is because it protects the trustee. Because the trustee is liable for misusing or wrongly disposing of any of the trust assets in a way that doesn't advantage the true beneficiary. So if somebody came along and said, well, I'm the beneficiary now because the first beneficiary assigned it to me, the trustees would be in, if that was true and the trustees refused to believe it, then the trustees are in breach of their duty towards the new beneficiary. But if it's not true and the trustees do believe it, then they're in breach of their obligations to the old beneficiary. And so basically what the subject guide concludes is that this is a rule to really protect the trustees. Now the issue with this is that doesn't quite fit in with Gray and IRC. Now in Gray and IRC, and you should read about this, but basically a more elderly man decides he's going to give some money to his grandchildren in the form of quite valuable shares, but he doesn't want to pay stamp duty on it. So what he does is he transfers, so he takes his legal and his equitable interest, he owns the shares and he separates them out, and his grandchildren all have just general trust because they're a wealthy family. he separates them out, and he gives the equity, or he gives the legal interest to the trustees who hold his children's trust, but he happens to retain the equitable interest for himself. So he declared a trust, but he declared a trust for himself, so he held the equitable interest. Perfectly fine way of doing a trust. It's what people who left on the Crusades were doing. They were giving it to someone else, but holding the equitable interest for themselves, so that someone else could deal with it as the legal owner. Perfectly legitimate. But because he held on to the equitable interest, at the time, this meant the tax rules meant that they paid very negligible tax on this, so there wasn't much tax to pay at all. And then a little while later, he made an oral declaration that now this equitable interest, so the legal interest, let's say, is being held by the trustees, he's holding the equitable interest, and then he gives the equitable interest to his grandchildren. But the legal interest doesn't move, so the tax people aren't necessarily aware of this. And so he makes this as an oral declaration. And then a few weeks later, the trustees then do the things that they make a declaration in writing, which they need to do, that says, well, now we're holding these shares on trust for the grandchildren. But because the equitable interest hasn't moved, now that they're held, the equitable interest is held for the grandchildren and the legal interest is held for the trustees, this written document doesn't change anything. And so the argument is, well, the tax people can't claim there's stamp duty on the transfer of the shares because of this legal instrument, because nothing's moved now. It's where it was before this legal instrument was executed. And what they said was that this oral direction that the grandfather had made to move his equitable interest from him over to his grandchildren, they said, well, this isn't a disposition under section 53 1c, and so it doesn't need writing to be valid. So there doesn't need to be stamp duty. The House of Lords wasn't having this. It was clever, they admitted, but no dice. They said that it was a disposition that needs to be done in writing, and so this oral declaration was void. Vandervelde doesn't quite do the same thing, and so you're going to have to read up on Vandervelde. I'm running out of time, but if you'd like me to do Vandervelde, perhaps you should let me know, because they are quite complicated cases. But just in the last couple of minutes that I have, the important point to think about with Gray is that, well, it doesn't make sense that section 53 1c, the rationale of it is to protect the trustees, because the trustees were aware of what was happening the whole time, and it wasn't the trustees who were sort of being made fools of here, it was the taxman. So why would that be the rationale of 53 1c if it operates even when the trustees are in on the game, really? So that's where I'm going to leave you today. I think what we're going to try and do is put through a questionnaire to you. I know that Millie and Karen have had some problems trying to get through to get some feedback from you. So I think we might try and do a questionnaire and to see if we can get some feedback, so I know really what you need to cover. All right.